Hi, I'm Mark Cohen. I'm InterNACHI's General Counsel. I've been the General Counsel since 2004. And my job as General Counsel is to provide top quality legal advice to InterNACHI and to InterNACHI members. One question that inspectors ask me a lot concerns arbitration clauses. And so before I talk about arbitration clauses, let me talk in a more general way about dispute resolution. Hopefully there is no dispute between the customer and the inspector, but sometimes there is, and there's different ways that those disputes can be resolved. One way is just through informal discussion between the client and the home inspector themselves, and we encourage that. If the home inspector settles a claim or potential claim, even if they think they didn't do anything wrong, we want the home inspector to get a signed release from the customer. But if you can't settle a dispute through informal procedures, the question is what's the dispute resolution mechanism going to be? One way you can do that is through what we call non-binding mediation, where both parties meet with a mediator and they try to reach an agreement, and sometimes that's helpful. If that doesn't work though, and there's still a dispute, the question is whether you're going to go into litigation, which is a lawsuit, which is decided by a judge or a jury, or instead whether you're going to do arbitration, which is where a neutral arbitrator makes a decision for you and is binding on you. So when you enter into an arbitration agreement, basically what you're doing is giving up your right to go to court. InterNACHI and me in particular are not fond of arbitration clauses. There's a couple of potential problems with arbitration clauses that inspectors need to be aware of. The first is that with arbitration, there is a wide variety of quality in the arbitrator. Some of the arbitrators may be retired judges or experienced business lawyers who are very good, but other arbitrators may not be particularly well qualified. So at least with a judge in the state court system, they've been through a screening process and they've been appointed by the governor, so you have some assurance that they're competent. Another concern with arbitration is there's no appeal. Even if the arbitrator gets the facts wrong or gets the law wrong, you are stuck with that decision. And sort of a third concern about arbitration is your discovery rights are very limited. You may not be able to do depositions or request documents from the other side. So those are some of the things we think about with arbitration. And it's also important to remember that arbitration clauses run both ways. So suppose you think you have a claim against your client. Maybe they defamed you on a website, and if you've signed an arbitration clause, you're not going to be able to sue that person for defamation. You're going to have to initiate an arbitration. So those are kind of some of the things we ask inspectors to think about before they agree to an arbitration clause, and those are some of the reasons that we do not include an arbitration clause in the standard InterNACHI pre-inspection agreement. So I hope that information was helpful. If you have any questions or you ever just want to brainstorm about a legal issue with us, feel free to contact us. Just go to internachi.org. All of our contact information is there. We love helping inspectors. That's our job. We like it. So feel free to give us a call or send us an email. We'll be happy to try to help you.